There was a motion filed today by Hank Brennan, and in that motion, he is asking the judge, Judge Cannoni, to compel the production of email and text communications between Karen Reed and, no, not Turtle Boy this time, but David Yannetti, her own attorney. Now, he didn't ask for the communications between her and Alan Jackson or Robert Alessi, but he is asking for the communications between David Yannetti and Karen Reed. Now, right away, a lot of people are up in arms about this because, after all, we know that there is an attorney-client privilege. And the other side is not allowed to see what communications went on between Karen Reed and David Yannetti. And for the most part, they're right. But we're going to see what specifically this argument is all about and whether there's any sort of basis in the law for this argument. So let's pull it up and let's go through the motion, and then we'll talk about the law. So here we go. The Commonwealth seeks all texts, emails, or written communications between the defendant, Karen Reed, and attorney David Yannetti, restricted to those communications that occurred between January 29, 2022 and February 2nd, 2022. So he is only limiting it for those 3 days. Now, those 3 days are obviously very important. Probably a lot of communications happened those days, maybe even incriminating conversations. So let's see that footnote he says there. You got that footnote number 1. Let's see what he says in the footnote. Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Because of an observed attorney-client communication, the phone data was provided with the assent of the defense to the Attorney General's office, and a court-ordered taint team protocol was implemented. The Commonwealth received the defendant's phone data with any privileged communications excised. Given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversations with Attorney Yannetti on January 29, 2022, and the following 3 days, the Commonwealth is entitled to the communications between the defendant and Attorney Yannetti for this waived narrow period of time. So let's see how she exactly waived that privilege. The privilege holder, Karen Reed, has waived her attorney-client privilege with Attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29, 2022 through February 2nd, 2022. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. Let's see that number 2 footnote. To ensure that only the communications that were waived are provided, the Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone data for the time between January 29th, 2022 and February 2nd, 2022. So that's where he's saying, look, I'm not asking for so much. And in fact, out of the abundance of caution, let's have Judge Cannoni have an in-camera review of all these text messages and written communications, and she will be the one to decide which communications get to go to the Commonwealth. So let's continue. In support of this motion, the Commonwealth acknowledges and respects that the attorney-client privilege protects privileged communications between a client and his or her attorney. And they cite the Mass Rule of Evidence 523 provides waiver of privilege. A, who can waive? A privilege holder or the holder's legally appointed guardian, administrator, executor, or heirs can waive the privilege. Okay, going to the next subsections are not really relevant to this discussion. So here's just citing the rule of evidence, which says that a client can waive that privilege. Now, an attorney cannot. Just so you should understand, an attorney cannot generally waive it. There are occasions where an attorney is allowed to talk about communications between his client. For example, if he's getting sued by his client for malpractice, then he is allowed to talk about those. But generally speaking, the privilege holder is the client. And the client at any time can waive that privilege by letting everybody know what he or she decided to talk to her attorney about. So that is true, that it's possible to waive a privilege. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with Attorney Yannetti regarding the collision between her vehicle and John O'Keefe. For example, in the defendant's recorded interview with Gretchen Voss on June 20th, 2023, the defendant concedes, question, you never said, did I hit him? I hit him. Answer, and this is Karen Reed answering, I said, did I hit him? And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's capability there, probably mean culpability there. And I thought, all right, maybe this is what maybe I said to my mother. Just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? Attorney Yannetti, Attorney Jackson, and Attorney Little were in attendance along with the defendant and Ms. Voss. Okay, so those were direct quotes from Karen Reed. And in those quotes, she is talking about things that she spoke about with David Yannetti. Second, in a Vanity Fair article entitled Karen Reed Tells Her Story, Part 1, a murder trial in Massachusetts, with a caption, as Karen Reed's second murder trial looms, she's ready to talk about what she says really happens, published on October 29, 2024, the defendant, who according to the publication was notably aware that anything she said could be used against her, volunteered a rumor that alleged representations made by the Massachusetts State Police that there is text message between her and counsel that implicates herself is a provable lie. Third, in the now airing 5-part docuseries on Investigation Discovery and HBO Max entitled A Body in the Snow, the Trial of Karen Reed, the defendant professes, and then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if I don't know? What if I ran his foot over? Or what if I clipped him in the knee and he passed out, or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. So those are quotes from Karen Reed, and she is referencing certain conversations that she had with David Yannetti. The privilege holder is the defendant, and the defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client, and that's true. He cites this case. See in the matter of a John Doe grand jury investigation, 408, Mass 4080, 1990. So that's the case that he quotes. In addition to rendering the communications non-privileged, the communications are relevant as admissions and statements of the defendant. These statements are admissible substantively, and Attorney Yannetti's statements to the defendant are admissible pertaining to the defendant's state of mind. Also, the defendant's admissions and Attorney Yannetti's statements are relevant to challenge the defense's later purported claims of third-party culpability. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Meaning the question here again is that even if he's able to get some of these communications, there's still a hearsay problem. So how are you going to get these communications? And even if he's able to discover these communications, what are you going to do about the hearsay problem? Now, the statements that Karen Reed made herself, okay, those are admissions by a party opponent, so those are going to be admitted. What about the comments that David Yannetti made? Well, his first argument here is that those statements would come in to show her state of mind, right? Not to necessarily come in for the truth of the matter asserted in those statements by David Yannetti, but for statements that go to her state of mind. And also to challenge claims of third-party culpability. The communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. Moreover, the defense has suggested that as part of its defense, it is likely to pursue a Bowdoin-type defense. The potential evidence is relevant to rebut claims of law enforcement contraventions. So that is the extent of the motion. So the first thing that we always have to ask when we're reading these motions, as you've been, if you're a follower of this channel, you know we always ask this question anytime that an attorney is asking the court to do something. And that is, what is the authority? What is the authority that allows a judge to allow a defense attorney to allow a prosecutor or defense attorney, doesn't matter, to allow an attorney to discover other communications between a client and their attorney? So he does talk about the fact that it's that you could waive this privilege, and he cites this one case in the matter of a John Doe grand jury investigation. So the first thing that you got to do is look at that case. So let's take a look at that case. And this is, I just highlighted the important part here. And this is really what he's talking about this from this case. Actually, I think this case, pretty sure this case is actually talking about where they wanted the attorney to talk about some of the communications that he had with his client. And here, while they're discussing that, they also discuss that this privilege actually is controlled. The privilege holder is the client. The privilege of insisting that the attorney keep confidential the client's disclosures made to the attorney in his or her professional capacity belongs only to the client. So unless the client allows the attorney to talk about those communications, the attorney is not allowed to talk about those communications, and therefore can be waived only by the client, or in some instances, at least by the executor or administrator of the client's estate. There has been no waiver in the present case. So this case really is talking about an attorney testifying, and they talk about this idea that the attorney doesn't hold the privilege. The privilege is held by the client, and only the client can waive that privilege. So in this case, it was an easy call for the judge, for the court to say that the attorney is not able to testify about something that the client told him. Okay, so that's all you see from this case. That's all you see from also all we're seeing from the cases that David Yannetti cited in his motion is that a privilege is waivable. Okay, so a privilege could be waived, but the question now is, at what point do the defense is the defense able to discover those communications? So there's no cite to that case, and also to what extent, what scope, how much of the communications is he allowed to discover? Now he asks for 3 days. And he's doing that to show that he's not asking for all the communications that they've ever had about this case. They're limiting it to what Karen Reed herself said in the interviews. But even then, the question is going to be, okay, but what's the scope? How much communications are you allowed to have? He wants all the communications. Where is the authority for that? And there's just simply nothing here. So I do want to make one point. And that point is that he has an argument that she waived that privilege. Because anytime that she tells a third party about communications that she had with David Yannetti, then she has then waived the privilege. She has waived the privilege in that respect. And I'm going to show you another case which actually stands for that. Take a look at this case. This says the following: disclosing attorney-client communications to a third party, including an accountant. In this case, it was talking about an accountant. But disclosing attorney-client communications to a third party, including an accountant, meaning it doesn't have to be an accountant, obviously, generally undermines the privilege. The attorney-client privilege generally applies only to communications between the attorney and the client. There are exceptions. In Judge Friendly's landmark opinion, the United States Court of Appeals for the Second Circuit recognized that the privilege can shield communications of a third party employed to facilitate communication between the attorney and client and thereby assist the attorney in rendering legal advice to the client. So here the situation is the following in this specific case. The situation was where you had a client, you had an attorney, and they met with an accountant, and they were talking about different things with the accountant. So the question is, are those communications protected under the attorney-client privilege? And any sort of memoranda that was made in that case, okay. But the point is, are those communications covered by the attorney-client privilege if there's a third person there? Now you're talking about the case. They are talking about the case, but there's a third party there. So the courts have found, and this is what this case stands for. If you read through the entire case, this is what it talks about. It stands for this idea that if there's another person there who needs to help facilitate the conversation between the attorney and the client. So for example, let's say you have a complicated tax matter and you're the attorney who's representing this person in court, but you really have to really understand what's going on in order to really be able to advise your client appropriately. And therefore you meet with an accountant together with the client, and you're just trying to wrap your head around exactly what's going on here and understand the laws a little bit better. And that way you can then represent your client better. Well, in that situation, those communications are not considered, they're not discoverable, and there's still a privilege there, because really those are just communications, again, to help the attorney represent the client and understand the client. So for example, let's say you have an interpreter. You have an interpreter, you can't really communicate with your client. Does that break the attorney-client privilege? No, because the interpreter is just helping you facilitate the conversation. But if that's not why you're going to the accountant, you're going to the accountant for other purposes, just to talk for other reasons, but not really to help you communicate with the client or help for the attorney to understand the issues, to be able to assist the client, well, then those communications are not going to be considered privileged. Okay, so let's try to apply this scenario to what happened here. Here you have Gretchen Voss, and you have the entire world really hearing about some conversations that Karen Reed had with David Yannetti. Now, number one is that what she says in that interview at that specific time, that definitely is not going to be covered by an attorney-client privilege. That you can definitely see from this case, because they are talking to the world, and all of those communications, even though her attorney is there, is still going to be discoverable. The question really then goes to is another layer. There's another layer here which really you have to dig deeper for. And that is, what about if she references communications that she had with David Yannetti, and those communications that she had with David Yannetti, there's nobody else there. It was just a text message. So does that mean that those communications are automatically discoverable? Does that mean that the privilege is waived because you are talking to the world about a communication that you had with your attorney? That's not so clear. And it would be helpful for Hank Brennan to be able to show some sort of authority that says that if you're talking to a third party, not just the actual conversations that you are talking to the third party about are discoverable, meaning whatever you say in that room, but also when you're referencing other communications that you had with your attorney at a different time, not with the third party was there, is that discoverable? So therefore, the number one argument against this is, number one, if you're the defense, the number one argument here is that you haven't provided case law. You haven't provided authority, which is exactly what Judge Cannoni asked in the previous hearing. Some of the questions that she asked to Hank Brennan is that you got to provide me some authority for this, which is, like I've always stressed on this channel, you got to provide authority to the judge to do what you're asking. He hasn't really provided authority. All he's provided is that there's an idea that some Karen Reed could waive a privilege. And that's true. That's a rule across the board. But then you have to also show that what she specifically did in this case constitutes a waiver. And what does that waiver cover? What's the scope of that waiver now? Has she waived all communications that she had with David Yannetti? Or what about the actual specific conversations that she is talking about? I spoke to David Yannetti. I said this and that and the other thing. And that's it. That's the limit of what you are allowed to discover. But Hank Brennan is asking for a lot more. And for that proposition, he just simply hasn't provided any authority. So when it comes to an attorney-client privilege, when it comes to specifically Karen Reed's conversations that she had with Gretchen Voss and what she said about when Yannetti spoke to her. So if you take a look, let's take a look for a second back. Here's one point. And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if I don't know? What if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. So maybe you can make an argument, if you're Hank Brennan, that those specific statements that she's talking about in this interview, those perhaps are discoverable. So if you want the exact text messages where he is saying these exact words, perhaps he has an argument that those are discoverable. But where does he get the idea that he can now discover all of conversations that happened over the course of 3 days? Where do you see that? Has he cited any sort of law that says once somebody waives a partial conversation, then all the rest of conversations that she had with David Yannetti is also discoverable? He just simply hasn't provided the law. Now, there is some research out there. There is definitely some case law that talks about that idea. And usually it's in the context of testifying. Usually the context is you can't get up in the stand and say, I'm only going to talk to, if you're a representative, right? Let's say you're a defendant. And so you get up on the stand and you say, I'm only going to talk to you about certain conversations I had with my attorney about this subject matter, but I'm going to stop it as soon as I'm done. So there's actually some support in the case law that says that no, once you're taking the stand, once you are putting this issue in front of the court, you can't just stop it by saying asserting this privilege. Once you waive the privilege for a part of the subject matter that you're talking about, so then the privilege is waived. So that's understood. That you can find in the case law. That's something that you definitely see that, and you have to be aware of. If you're a defendant taking the stand, then you can't just cut it off at any point and say privilege. Obviously, you can't do that. It doesn't make any sense. Here, this is a very different situation. Here you have somebody talking to a third party, Gretchen Voss, or the entire world for that matter, because it's publicly available, and she's saying specifically a certain conversation she had with David Yannetti. So where do you get this idea that now I can discover all the communications that she had with David Yannetti over that period of 3 days? You just simply don't have it. You don't have the case law. He didn't cite the case law, and he didn't even make comparisons to other cases where you have this type of issue, which I just laid out for you, that you do have some sort of situations like in court when somebody takes the stand. He didn't make any comparisons to those cases. So he's just relying on one case which says that a person can waive the privilege, and that privilege is held by the client, and that's it. But you don't see any sort of scope. You don't have any support or any authority to say why you get all 3 days of conversations. So definitely the argument number one here is that you haven't provided any authority. Number two is that even if you want to say that some of these communications are discoverable, it's only limited to what she specifically said that her conversations were with David Yannetti. If you want to get those exact text messages, maybe you have an argument to make. But to say that you get all 3 days of the text messages, that is just simply, there's no support for that. There's no authority, definitely, that he did not provide. Now, like I said, if you would have made comparisons to some of those other cases, you can start to have an argument. And again, you can still distinguish that those cases are very different. You're the one that's putting the issue in front of the court, and therefore you can't just cut it off. There's definitely distinctions that you can make between those cases that I spoke about and this situation that we have in front of us. So what I'm saying is that it's a bare bones motion. There's very few citations to any sort of authority, and therefore it's it's just a weak motion. So what I see happening, like I said again, what I could potentially see happening is that maybe Judge Cannone will allow him to say, okay, you get those specific text messages this is what the ruling probably should be, that maybe you get those specific text messages that she spoke about in that interview, specifically those text messages, but nothing else. Why should you get anything else? Why should you get email communications between them, between those 3 days? It's just you're trying to exceed the scope. It's too broad. And you haven't provided any sort of authority that says that you get all those extra communications. So that is my take on this specific motion. And we'll see what happens as we continue to watch and follow this case. So that's going to be it for now. I am still thinking, I know right now it's Friday. I'm thinking about perhaps doing a live on Sunday, maybe having it open to talk about all the different issues that happened in the Karen Reed case and opening it up for questions if any of you guys have any questions about that. So maybe we'll do something like that on Sunday. Keep your eyes peeled. Let me know in the comments if you want me to do that. We'll just maybe have a very casual session. We'll just talk about the general issues that are going on with this case and all those motions and hearings that were brought up, all those issues that were brought up in the previous hearing. Maybe we'll do that. I'm still thinking about it. But let me know in the comments if you'd appreciate that. Maybe we'll do it on Sunday. But until then, everybody have a great weekend. That's going to be it for now. And we will see you next time. If you haven't, subscribe and like, and we will see you next time.